everyone. My name is Giovanni, and I'm a paralegal here at Liles Parker. Thank you for joining us for this new webinar series with the Home Care Association of Louisiana. Today's webinar is entitled Sensitive Issues in Home Health and Hospice Employment. Quick reminder, if you have any questions throughout the presentation, please feel free to type them in the chat box, and we'll address as many as possible at the end of the presentation. Also, I will be sending out the PowerPoint slides tomorrow via email, so keep an eye on that. So without further ado, I present your speakers, Michael Tobin and Robert Liles.
Thank you very much, Giovanni. Really appreciate it. This is Robert Liles, and I'm here with my colleague, Michael Tobin.
Hey, everyone. Thank you.
We were originally supposed to do this presentation on the 30th,
yes.
But because of other case conflicts, we moved it up to the 24th.
Mm-hmm.
And today we are going to be talking about sensitive employment issues.
A wide range of issues, yes, and issues that are going to be important for, not just healthcare, but all businesses. So we're looking forward to talk about them today.
Right. But before we do that, I think that we would be remiss if we didn't talk about what happened yesterday. What happened yesterday, Mike?
Exactly. So there was an update the DOJ submitted yesterday, the 23rd.
The press release, right? Announcing it, yeah.
Yeah, and it was on the National Healthcare Fraud Takedown, which was very extensive this year. We talked about it being broad. I believe there were 45 states that it actually covered. And just a brief overview of it, there were 455 defendants, almost 100 doctors that were charged there, and then illegal schemes involving over $6.5 billion in false claims. So, extensive.
Right. So before we get into the employment issues, I wanted to cover some of the home health and hospice issues that really were involved in yesterday's takedown, because, that's a big deal for them to arrest almost 500 people in a day, or indict them. They may not have they may not have taken them into custody yet.
Yeah.
But this is very significant. It's really kind of become a tradition, if you will, for DOJ to do something like this in June or July.
Mm-hmm.
Most recently, the last few years, it's been in June. Next slide. Okay, so let's talk just about a couple of the hospice cases. I mean, there are the cases we're going to go over just very quickly. These are just a thumbnail of some of the cases that are included in those almost 500 defendants. The first one, Mike?
Yeah, so there were essentially, and these are all based around beneficiaries that didn't qualify for hospice services. And out of California, we saw patients or individuals who were not terminally ill, not qualified for hospice, services billed for patients that were already deceased. That's something that we see also a lot as well.
Yeah, this second case could be a law school exam, identifying all the different causes of action.
It could be.
Unbelievable, yeah.
Mm-hmm.
Yeah, and go over those issues. They're just remarkable, the breadth of improper conduct. And the only reason we bring this up is because we know our friends in Louisiana wouldn't be doing this, but it gives you a good idea of what the government's looking at.
Yeah, I mean, ethics certainly comes into play as well when we're looking at that. I know one of the cases was for a hospice owner paying a funeral home for the death information of beneficiaries, and then going back and then making documentation to submit saying that they were part of their hospice, just to try and lower a percentage of patients discharged alive, which is something that CMS looks at. So, that brings in just, obvious misconduct that we shouldn't be seeing.
Right. And what about this one here where they were paying the beneficiaries illegal bribes?
Yep.
And it's not just cash. When you talk about bribes, they were giving them groceries, alcohol, furniture.
Yep, it could be anything. We could look at kickback issues as well when it comes to those different categories there, groceries, alcohol, and such. So essentially, taking advantage of these hospice beneficiaries that don't know any better, and then benefiting off of that. So that's what these crackdowns were really about. And
one of the other issues that they had here, of course, were illegal kickbacks to patient recruiters. Now that's, even though we're talking about hospices right now, that really plays over into the home health area as well, because many of our clients they either, well, they employ, in most cases, marketers, right? And, we've had cases where even though they thought the individual qualified as a bona fide marketer, they were paying them with a W-2, they were taking out taxes. There are a complete list of factors that the government looks at, and just because you're paying them like you would an employee does not mean that they qualify as an employee. And if they don't qualify as an employee, well then, of course, if you're paying them based on value or volume, that's a violation of the anti-kickback statute. So for everyone on this phone, look at how are you getting your business? How are you getting referrals? And if you're using marketers, you need to look at that very carefully. Have your attorney look at it. Next slide. Okay, let's look at a couple of home health cases.
Yeah, home health cases as well. So, here we saw down in Iowa, 350,000 claims that were not actually provided to elderly and infirm veterans, including those for veteran clients that passed away. So we see that again, services that are actually impossible due to people passing away. And then not only, purporting to do those services, but then proceeding to pay off sports gambling debts and other expenses. So that's kind of adding insult to injury there.
Exactly. And the personal care cases, I included this or this category on here because many of our clients, our home health and hospice clients, a lot of times they also have a side company where they provide personal care services. Okay, that's typically reimbursed by Medicaid, and it may be someone who of course may not qualify for hospice or even for home care, but the fact is they do qualify for personal services. The reason I think it's interesting here, though, is that this is just a handful of the cases, of the personal care cases around the country that were announced yesterday. I think this has all the earmarks of a national review. Medicaid, I believe, has been given the word by the government, CMS, OIG, and DOJ, saying check out these folks because we're paying too much for Medicaid services that are not actually being rendered. I also think it's interesting in that a number of the cases that are being brought against the caregivers, and they are going after both the individuals that supposedly provided the care and in some cases the companies themselves because they should have known better, okay? But they're looking at the electronic visit verification entries, okay? So that, those have been around for years now, but this is the first time that from a national standpoint, I've seen them really use that information to go after these individuals on a broad scale.
Yeah, especially when you look at that last one in Illinois here, where you see the caregiver was actually clocked into a secondary employment job at another location. So how is the caregiver at that point providing these services?
Yeah. And who knows how long they were doing that when they finally got caught.
Yeah, exactly.
I will say we have also seen cases over the years where the personal care recipients, their families, were also, they were lower level bribes or kickbacks, but they were giving them things of value as well in order to, I can't show up next week, but here's what we're going to do for you, that kind of a thing. So you got to be careful, guys. I mean, the government is very active right now. They're spending a lot of money in a bunch of different ways, and one of the ways that they can cut costs, of course, is to identify areas of fraud. And healthcare, of course, is the primary area that they're focusing on. As we discussed before, if you add up all of the healthcare fraud cases right now being pursued by DOJ's criminal division, okay, and you add up every other white-collar type of case, whether it's Foreign Corrupt Practices Act, bank fraud, every other one together, they would be half of what they're doing for healthcare.
Yeah, exactly.
So it really is the 800-pound gorilla.
Yeah.
I mean, that is what is taking up DOJ's focus and time. We don't want y'all to be part of that focus.
No.
All right, so we just wanted to briefly cover that. Now we're going to get into the primary topic of the day. And these are various sensitive areas that folks need to be watching for. From an employment standpoint, just right off the bat, everyone on this call needs to be screening their individuals, their employees, agents, and contractors and vendors against the state and federal exclusion list. And this is especially important in Louisiana, because in Louisiana, if you wrongfully bill, okay, for Medicaid, you know, and it's related to an excluded party, someone who has been excluded because they've been, you know, it can be as serious as they've been convicted of healthcare fraud, or as mundane as they have failed to repay a government-backed loan. Okay, so they've been put on the exclusion list. It's permissive, but it's still exclusion. In Louisiana, it's an actual crime. Okay, so it's not just, you're not necessarily just facing penalties. You're also facing you know,
potential criminal liability.
Criminal liability,
yeah,
exactly.
Yeah.
Next slide. And, you know, many of you will say things like, well, we use these you know, before we hire anybody, we do a complete background check. A background check does not cover exclusions, guys. It doesn't do it, okay? And I will tell you, there are companies out there, you know, that actually advertise, hey, you want us to help you put together a fake background?
Yeah.
We can help you with that. Fictitious references, white lies, alibis,
Yeah.
okay? So get your people screened. It's inexpensive. Go to exclusionscreening.com. Next slide. All right, now we're going to really talk about something that's really important, and it's very timely. The Civil Rights Act of 1964. And what does the Civil Rights Act cover?
Yeah, so it's going to prohibit employment discrimination generally on a number of categories, including race, color, national origin, religion, and sex. And then we're going to talk about later today what else sex includes. It's going to include pregnancy, gender identity, and sexual orientation. And so Title VII is going to apply to employers with 15 or more employees. It's going to be enforced by the Equal Employment Opportunity Commission, and that has been since 1964 as well. And just to talk about generally, these protections, they don't require any employee to change their beliefs. And another good point is that contrary state law is not going to be a defense under Title VII. So the heart of it really is protecting people from discrimination in the workplace based off of those categories laid out.
It is. And I will tell you up front that if any of you have ever dealt with the EEOC before, Lord knows the way they're dealing things today is different than the way they did it in the last administration. But the laws, most of the laws we're going to talk about today have not changed. Okay, the Supreme Court, we're going to talk about issues that the Supreme Court has already had rulings on, and the law is fairly settled. That doesn't mean that EEOC is going to be as forceful in some areas as they were before, but the fact is the law has not changed.
Not changed, and sometimes expands, as we'll see later. Too.
That's right. Next slide. So let's start with religious discrimination.
Yep, so religious discrimination. This first one is somewhat timely still. The COVID vaccination back in 2020 was a big issue in a lot of workplaces.
There are so many places. In fact, we in the military and in all kinds of employers said if you don't get the inoculation, you can't work here.
Yeah, exactly. And
they were firing people.
Yes, and that's where this religious aspect comes in here. You know, there was an employee down in North Carolina saying that their sincere religious beliefs were that receiving vaccines was inconsistent with God's will. So, you know, it was held, Title VII controlled this here, and it was, you know, the EEOC said as long as doing so does not pose an undue hardship of the employer, you know, the employer has to make a reasonable accommodation of these sincerely held beliefs. And so, yeah, this group down in North Carolina, the hospital ended up having to pay $150,000 and then entering a 2-year consent decree saying that they would not be discriminating on a religious basis. So you think about something like a vaccine there, you wouldn't normally think about how religion could come into play, but Title VII comes into play, EEOC is here nonetheless.
It does. And Lord knows, just recently, in the last week, this whole issue of Dr. Fauci and COVID and the rest of it is back on the front page of the papers because Congress and the Senate are looking into what was known by the government, what was not known by the government, and were there in fact lies and alibis that were being done. So it's a pretty sensitive issue right now everywhere. But I do think it's interesting that employers were firing people left and right for not doing it.
Yes.
And now everybody's saying, we probably didn't have the right to do that.
Yeah, wait a second. Let's go check that.
Yeah. Okay, next one. Now, this is a very interesting case. It's not a new case, but the law is still good. And that is, you can't make your employees sit through Bible study.
No, you cannot, nor religious workshops or spiritual cleansing rituals either. Part of a belief system called Harnessing Happiness or Onion Head. So this is some of the strange things.
Have you ever heard of Onion Head before?
I never have.
Me neither.
But these are some of the strange things that are going on. This was New York, and the jury ended up awarding $5.1 million in compensatory and punitive damages to 10 individuals who are complaining religious discrimination there. So just as a general business tip, it's probably not good to be having everybody go for the belief system of Onion Head.
Yeah, and I will tell you, I have clients who have healthcare organizations, and they are very, very devout Christians, and that's part of their mission statement. They aren't at all afraid to tell people that we do this partially as not just as a business, but it's part of our mission to help the infirm. That's not against the law. But when you start making people participate in that, in your beliefs, that's a problem.
Yes, it is.
Okay. So what
we've got
let's talk about this case.
We've got another one here, Texas medical practice, similar vein here, firing a Buddhist employee for repeatedly requesting to be excused from a daily morning Bible study. So again, we talked about the importance of religion and such, but when there's requests to be excused from these studies, that's when we're going to get into, EEOC issues. Federal court ended up, ordering this group to pay $375,000 as well. So these can stack up, these penalties too.
They can. All right, just to summarize it, what exactly does Title VII say religion includes?
Yeah, so it's going to include all aspects of religious observance and practice as well as all beliefs. So that's broad there. Observance and beliefs. With all the different religions out there, there's many different ways that things can be observed, and beliefs as well, of course, as we know, are all over the place. So
yeah. All right. Now let's talk about one that really kind of hits home for the people on this line. Okay. Sexual discrimination, sex discrimination. Okay, and can a home health or hospice patient say, I only want to be treated by a male or a female? Now, what's the general rule? You can't discriminate against somebody based on sex, right? Mm-hmm. And just because your patients want you to, doesn't mean you can get a pass to violate the law.
No.
But what about this issue?
Yeah, so this is a maybe, and in the legal world we see a lot of maybes. And that's going to depend on, the circumstances. Now, a patient in home health or hospice can ask for male or female only caregiver, but this is generally going to be in situations with intimate bodily care involved.
So if they're having to do baths.
Yep, that would
change out catheters.
Changing. Yep.
Or I will tell you, I've had a case where the family and the patient, they were Muslim. Mm-hmm. And, it was a female. And they said it was a religious issue. Mm-hmm. That's what they were basing it on, that they couldn't have another man taking care of mama.
Yep.
I think that would probably, I haven't found a case on point to that effect, but I think that would fit within this type of exception.
Yes, I agree with that. And it is important to note, though, that a patient can't compel a provider to adopt a blanket sex-based staffing policy unless you can get into this very narrow qualification or exception, the bona fide occupational qualification, which we'll talk a little bit more about.
Yeah. All right, so what is that?
Yeah, so
BFOQ.
it is an exception, a standard. While there is, this general rule we talked about, there are some extremely rare instances where a person's sex, religion, national origin may be reasonably necessary to carrying out a job function, some of the things we talked about, maybe the Muslim religion.
Now, can you think of an example of national origin? Why would that be a BFOQ?
That's very tough to say. Yeah, why would it be?
But I will say, I mean, this is what EEOC says, and like I said, I couldn't find a case on religion, couldn't find a case on national origin, but those are, they're maybes.
Yes, and that's why we highlight how rare these exceptions are, how narrow it is. Important to note, race is never going to be included in this exception.
All right, so you're growing up in the Deep South. We're talking about people that are in their 80s and 90 years old. They've got some hardcore beliefs that they were brought up with, and maybe they say, we don't want Mama being taken care of by someone of X race.
Mm-hmm. Not going to be allowed at all, and that goes back into what you said. It's the provider's decision that's going to be looked at, not the opinion or whatever the desire is of the patient, and so that's what providers need to be well aware of.
Now, what if you have an employee, though, that comes to you and she's a black female, and she says, I prefer not to take care of these folks because they're really not respectful to me.
Yeah, you're running into issues again there, depending on, you still don't want to discriminate.
Can you accommodate the employee's request?
Well, that's more of a gray area, too, but you run into because you don't want to be discriminating against the patients as well.
Yeah, but if that's what the patient wants, that's what the employee wants, I think you probably have a pretty good argument at least that you're not trying to violate anybody's rights. Yeah. You're trying to accommodate everybody's requests.
Yeah.
Okay? But if it's just the patient and their family, they really are not in a position to, and I know you're saying, hey, that's a business decision. No, it's not. It's not because it's not a protected class, and you especially if you don't have other work that individual could do somewhere else, I mean, if you end up having to, lay off on hours or lay people off, I think you've got a real problem.
Yeah, those are adverse actions that we'll look at a little bit later as well.
Yeah. Okay. All right. So this is back to the BFOQ situation,
Yeah. So in those cases, there are cases where same-sex staffing has sometimes been lawful when those more intimate situations occur, the bathing that we talked about, the changing and such. Just in instances where the privacy can't be protected by less discriminatory means. So it emphasizes, this narrow exception too, and just only some situations where same-sex staffing is lawful.
Yep. Okay. All right. Transgender. That's a very topical issue right now.
Yeah.
But let's talk about what is the law and has the law changed?
Yeah. So we can talk about this landmark decision here, Macy versus Holder, and this essentially was a ballistics job where an applicant was told that she would receive the job. She was later told the employers that she was in the process of transitioning from male to female, and then she was told that it was no longer available due to budget cuts. So the reason this is the landmark decision is for the first time EEOC said transgender discrimination is going to be covered by Title VII, and it's going to be within the umbrella of sex discrimination under Title VII. So this was just 2012, just highlighting the emerging issues of transgender discrimination. But yes, it is covered by Title VII.
It is covered, and they do have protection, and that hasn't changed. That is the law. But now, Michael, we keep seeing on the news that the current administration is in the process or has already fired all the transgender members of the military. So you're telling us that the law is you cannot discriminate based on sex, and transgender qualifies as sex. How is the military getting away with this?
Yeah, sometimes the laws just aren't followed. We talked about it with the vaccines earlier.
Well, but I think though what the military would say is that, if you are someone, if you want to join the military tomorrow, but you're diabetic and you're insulin dependent, that's a disqualifying factor. Mm-hmm. They will not take you in the military because they are not set up to transport and refrigerate insulin all over the world in war zones, okay? Mm-hmm. They would say that transgender is similar in the sense that they have to be on hormonal therapy. Mm-hmm. They don't carry that stuff with them.
No.
That's an ongoing kind of treatment, just like a diabetic. Mm-hmm. And therefore, they don't qualify, they don't meet the fitness requirements, I guess.
Yeah, and that's just one of the issues that is going to, continue to evolve, I'd say, as we get more into this.
Now, it's interesting. I think that's why one administration took the position that it was fine, because I guess they were willing to change the qualifying requirements for the military during that period, okay? Versus this administration is not willing to. Mm-hmm. They say, we're going to treat this person just like we treat a diabetic.
Exactly, and that just highlights how administrations, change from administration to administration. We see different opinions, different outputs on these.
Yeah. Next slide. Okay.
So we had a couple more sample transgender cases, one North Carolina, one Pennsylvania. Essentially just more of the same, certified nursing assistant, denied for several positions because at the time of her interviews she was anatomically male, undergoing the hormone replacement therapy, sex reassignment, and then the court ended up allowing the plaintiff's transgender discrimination claim to proceed under Title VII. So just more examples of the willingness to include transgender discrimination under Title VII.
Yep.
And another one there, transitioning male to female, and not conforming to the employer's gender-based expectations, preferences, or stereotypes in violation of Title VII. So that's an issue that we see Pennsylvania, North Carolina. It's going on around the country.
Okay. Couple other cases.
Couple more here. We had Case Lewis down in North Carolina as well. So another certified nursing assistant, so that's been a common thread in some of these. Denied hire for several positions because of transgender status. Again, at the time of interview, anatomically male, undergoing replacement therapy. That's been a common thread as well in these cases. Court allowing, again, moving forward under Title VII. And then Florida, another one. EEOC then suing Lakeland Eye Clinic, another business there, for the alleged discrimination, again, based on sex, for a transitioning male to female under Title VII.
So that really hadn't changed. I mean, the bottom line is, when you're looking at applicants, you need to look at their experience, their education, and their skills, and not really what their biological or
any transition that's going on.
That's right. Can they do the job, and can they do it well, and are they qualified? That's really what you got to look at.
Exactly,
right?
Exactly.
Okay, now we're going to take a little bit of a twist. Okay?
So, gay as well applies to that. We've got the case, Bostock versus Clayton County. That was another one, 2020, where the employer violated Title VII as well for taking adverse actions against an employee for being gay or transgender.
And this is important because this is the U.S. Supreme Court, and that's why I wanted to bring this case in, because the original EEOC important case was what, 2012?
Yeah, 2012, the landmark.
But here we are, fairly recently, 2020, and the Supreme Court says that being gay or transgender falls within the because of sex.
Yep.
Okay, so now the Supreme Court has made it very clear this is the issue. Okay,
it's protected. It's the law of the land.
So what would be an adverse action then?
Yeah, so an adverse action can be broad as well. We touched on this earlier. A reassignment, not assigning somebody to a patient, reducing them in schedule, removing them altogether for a case, or really, a broad one, any work limitation that's imposed because the worker is gay or transgender, or any of the other classes that we talked about. So adverse action is broad.
It really is. It really is. And, once again, home health or hospice, the provider's going to say, look, we're trying to make a living here, okay? We're trying to keep the doors open and the lights on, all right?
Mm-hmm.
And if we have patients who don't like our caregivers, we have to take that into account when we make assignments.
Well, that's where we look at what Title VII focuses on, and we touched on this earlier. It's going to be the employer's action, not the source of the preference. So the employer can't go to EEOC and say, well, this is what all of my patients wanted.
They're
not going to buy that.
Yeah,
no.
So that really, the bottom line is, just because your client wants to discriminate does not give you a pass.
No, exactly.
Okay?
Yeah.
There are some very narrow exceptions for those BFOQs.
Yep.
Like intimate care and that kind of thing. That makes perfect sense.
Mm-hmm.
EEOC, but you better document that, guys. You better document that.
Exactly.
And exactly why you think it meets that BFOQ. Mm-hmm. Because if there's ever, this stuff, nothing ever happens then. It's later on when something happens, and then you have somebody files a complaint against you. Document why you're making these decisions.
Mm-hmm. Exactly. It's always in the documentation. Healthcare, we know that very well.
Yeah. Okay. All right. Same thing. We asked before about the sex, didn't we? And possibly religion. Okay. Well,
mm-hmm.
Can a home health or hospice accommodate the request not to have a gay or transgender caregiver?
That's going to be a no there. You're on dangerous legal ground with these adverse actions.
And I suppose it could go the other way. What if they say, we only want a gay caregiver?
Yeah, then you're discriminating, the other way as well. So that's going to be an adverse action. Removing a nurse from a case because the patient learned the nurse was gay, refusing to assign a transgender aide, adopting an internal practice, matching only non-LGBT staff, or reducing hours or opportunities.
Those are all adverse actions.
I know, yeah.
And those are all actionable, and they can all, they can hit you with damages.
Exactly, they can. Remember that, as we said, those small exceptions for the intimate situations, bathing or toileting, and then also for grounded in privacy, modesty, and trauma history. So there are some exceptions. They have to be narrowly tailored, it says there.
Yeah, that's interesting about the trauma history. That's not, that came up when I was doing some research, but
mm-hmm.
I hadn't seen that, of course, in most of the.
Mm-hmm.
So that would be a BFOQ, I believe.
Yeah.
If you could show that for this particular patient, they've been through a lot, and here's what they've been through, and this is why we accommodated that request.
Mm-hmm. And document that well, because you can't just tell EEOC that. You've got to have documentation to support.
Yeah. Sexual harassment. That's another area that has been around for quite a while.
Mm-hmm.
Okay.
Yes,
what is harassment, first of all?
It's going to be another broad one. Sexual harassment, unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature. So again, this is a broad one, like the discrimination, like adverse action we just talked about. This is going to be broad.
Now, next slide. Now, one thing that kind of pops up, it's rare, it's not impossible, but it really is rare that our clients are the ones who are accused of being the sexual harasser, mm-hmm. if you will, okay? Yeah. It's not unusual, though, especially when you're dealing with people who are, either they have dementia, they may have some other type of mental illness, later in life, for them to say things or do things that, that you shouldn't do.
Yeah, exactly.
Okay, and this is a very recent case,
mm-hmm.
That EEOC announced out of Colorado.
This was Colorado, yes, and this is very important.
And this one wasn't even from the patient. This was from the family.
No, exactly. So there was a home health nurse that was sexually harassed by the son of a patient. And, we look at 29 CFR there, and an employer can be responsible for the acts of non-employees. So that is quite the liability that can be imposed from this.
You got to protect your staff, folks. I mean, obviously you have to protect the patients, but you got to protect your staff too.
Mm-hmm, exactly. And the employer, to further on that, if they know or should have known that the sexual harassment conduct, and mm-hmm. failed to take immediate and appropriate corrective action, then you start to run into issues. So make sure, if you hear of any of this as an employer, any kind of sexual harassment going on, be on top of that quickly.
Now, let me ask you, this is just, and I haven't asked you this before, so I'm putting you in an unfair advantage, okay? But what if the employer, what if the home health agency says, okay, thank you, nurse, for bringing this to our attention. You do not have to go back out there again, okay? We're going to send a man over there from now on, okay? Now, would that be a BFOQ? What, I mean, what do you do? And what if the family then says, no men?
Yeah.
We need the intimate care. I mean, what are you going to do? Discharge the patient? I mean,
I would document it thoroughly, first of all. Make sure that it's well documented that there was an issue with a woman before. Talk to the family again. Let them know that under the Title VII, we can't have this blanket sex discrimination and say, we're sending over a man.
But then, we could have other problems there.
We could, yes. See, still have to meet the exception.
Yeah. So at that point, then, what are we going to do?
Yeah.
So every one of these cases, there's a lot of moving parts, and you've got to kind of figure out exactly what you need to do to minimize your liability, protect your staff, protect your company, and protect the patients.
Exactly.
Okay. ADA.
Yep. ADA is going to be another important regulation prohibiting discrimination against people with disabilities in several areas, employment being the most pertinent one for today. And a qualified applicant under the ADA is going to be a person with a disability who, without reasonable accommodation, can perform essential functions of the job in question. And so that's going to be another issue that we'll look at here. And that can be a wide range of issues, we'll see.
Yeah, I will tell you, we've got this list up here. Pregnancy is a huge issue right now at EEOC. You can't discriminate against someone because they're pregnant. Now, pregnancy,
breast cancer, epilepsy, and hypertension as well down there.
And I believe all of these, I think, were healthcare related cases. So ADA issues are things that come up, and but for the grace of God goes, all of us have had family members who have come down with cancer.
Exactly.
All of us. And how would we feel if our family member was discriminated against, or they had an adverse action against them because they had cancer, something completely outside their control?
Outside their control, and something so common that how are you going to discriminate against?
Right. And this epileptic here failed a drug test because of her epilepsy medicine. I mean, now once again, would an epileptic meet the requirements to join the military? Probably not.
No.
That's probably a disqualifying condition. But for regular employment and for home health and hospice, you can't hold that against them.
Exactly.
Okay? All right. Here is a pregnancy case.
Yep, so this was down in Wisconsin.
Fairly recent.
Yes, fairly recent, 2023 as well. ADA was at issue. A scheduling coordinator that was pregnant with hypertension as well was discharged because of those conditions.
Yeah, and I don't even get this one. I mean, it's not like it was a home health agent or a home health nurse who had to do a lot of traveling and go up and down steps and do all, you know what I'm saying?
No, just
this was a scheduler.
Exactly. So, not sure what the additional rationale there was, but they ended up having to pay $20,000 to that former employee. And, that highlights that pregnancy discrimination and disability discrimination are protected under the ADA.
Yep. All right. Now, let's talk about a very, very timely issue, marijuana. Marijuana's in the news. And, we're sitting here in D.C. And in D.C., do you know what the status is of marijuana?
I believe it is decriminalized.
It's decriminalized, right? And there are places where you can actually go and buy it.
Yep.
I think you can buy other types of illicit substances too, possibly.
I think so.
But everywhere is different.
Exactly.
It's different in Virginia, although it's decriminalized in Virginia. In Maryland, I believe it's pretty much the same thing. In Oregon, for a long time, all drugs were legal, or at least they were decriminalized, and then it got so bad that they reinstituted penalties for them. The problem is, when it comes to marijuana, that the laws vary from state to state. They also vary from federal to state, okay? Because, the fact is it's still illegal federally. And if you think that, well, it's legal in my state, so I can't get in trouble for it, well, you're wrong. The government actually still brings marijuana cases against folks. And a lot of times, they're doing other things too, but it's an easy thing to do because it's still a violation of federal law, okay? Just real quick, let's kind of look at the background. I mean, it goes almost 100 years back in 1937. They used to just sell it in the pharmacies, and they may be selling them in the pharmacies in the future. Who knows? But they had a tax that they first put on it, and then the Supreme Court struck down the tax, and then they passed the Controlled Substances Act, and they put it into Schedule 1, which is a high potential for abuse and the potential to create psychological and/or physical dependence. No currently accepted medical use. Now, this is really interesting because over the last 50 years, I can't tell you how many times I have seen people say it's non-addictive and it doesn't hurt you, there's nothing wrong with it, it's just the government doesn't like it for whatever reason, right?
Exactly.
But now if you actually look up on PubMed, almost every week there are new articles talking about the adverse impact of marijuana. So, I have to tell you, Mama was right.
Yeah.
Okay? Mama was the best compliance officer ever.
Yeah.
So it's the kind of thing where even now that it's legal, the fact is they're actually really doing studies on it now, and they're finding out that it does have severe impact health-wise in a bunch of different ways.
Yes, exactly.
Okay, so what is, just very quickly, just so we can kind of explain to everybody why it matters on the federal side, what is the Controlled Substances Act?
Yeah, so it's going to establish 5 different schedules. We talked about Schedule 1 there, no currently accepted medical use and treatment and that in the United States. And then 2, the lack of accepted safety for use under medical supervision.
And that's what it's been for marijuana. It's been Schedule 1 forever, since 1970, right?
Yeah, until this April 2026 here. So there has been movement of recent placing marijuana products regulated by a state medical marijuana license. So that's an important factor there. It's not just everything you're getting on the streets, to Schedule 3. And so Schedule 3 is
once again, it's still a controlled substance.
Still a controlled substance, yes.
It's still against the law, unless you have a proper prescription, possibly.
Schedule 3 there, potential for abuse is less than drugs under Schedule 1 and 2. Currently accepted medical use, so we talked about the different studies that are coming out now. Arguments on both sides, Mama as well, still right in many ways. And then the third factor there, abuse may lead to moderate and low physical dependence or high psychological dependence. So there is some dependence there that is characterized in Schedule 3 as well. Yes.
So, but that is, from what I understand, that they've announced that they're doing it. Okay, but it has not gone through the complete rulemaking process yet. So I think that officially it's still Schedule 1.
Oh, yes.
But it's going to be Schedule 3. They're going to have to go through a lot more before they're going to move it over. I think they will move it over. There are so many states where it is legal now, or legal-ish.
Yeah.
But it hadn't happened completely yet. Next slide. Okay, so let's talk about Louisiana, because we're talking about Louisiana issues, right?
Yes,
so
we are.
What is the status in Louisiana? It's about the same as it is in Texas, and that is it's illegal.
Yeah.
Okay, Louisiana has a very limited medical marijuana program. Texas has a even more limited medical marijuana program. There's only like a handful of places that could even possibly do it, and in Texas it's only for like 3 or 4 different diagnoses. So you can't do it because you're anxious or depressed or no. It's for very specific eye problems in Texas, I think is what it mostly focuses on. But the point is, Louisiana is not D.C., Louisiana is not Virginia and Maryland. Okay, you may get away with it if you're caught with it in those states and you have it for personal use. You're still against the law to grow it for sale or production or pass it out to a third party.
Yeah.
Okay. but in Louisiana, it's all still against the law.
Yes. And possession, distribution remain criminal violations, as we say. And also of note is that subsection A of the Louisiana Revised Statute 49 there does not prohibit negative employment consequences for an employee who uses or is impaired by marijuana on the employer's premises or during work hours, or one who is primarily responsible for operating a state vehicle as well. So there are potential negative employment consequences for marijuana use.
Wow. Okay, all right. So let's talk about, what about Louisiana Home Health and Hospice?
Yeah, so generally able to prohibit employees from consuming marijuana, including off-duty uses, unless a specific statute limits the employer's discretion, of course.
I can see why they say that in Louisiana because it's illegal, period. Okay? I think you would have a hard time with that kind of position in Virginia because it's not illegal in Virginia for home use, perhaps, or D.C. But in Louisiana, you can prohibit people from smoking dope even at their own home, off duty.
Off duty, yes. And
now, how you're ever going to enforce that, and whether you should enforce it, I'm not going to comment on that. I'm a kind of a libertarian type guy. I don't smoke, I don't drink, but I think it's your God-given right to do what you're going to do, as long as it doesn't harm me or other people.
And that's an employer-to-employer thing down in Louisiana.
It is. So, all right. So, is anything else on marijuana?
Just an exception there. There is, and this is narrow again, for just state employers. There's an anti-discrimination protection for medical marijuana users. That's only going to apply for state employers and never on the job. Private health care providers, that's not going to be the case there.
Okay, all right. Bottom line is, don't smoke marijuana. Okay, on or off the job. And I say that just because, it really isn't good for you. Look at the latest PubMed articles and journal articles out there. It's just not good. Okay, stalking.
So stalking is another one here that we've got broad range of discrimination, broad range of harassment. Stalking is another one. It's a definition, and we're all familiar with these, but just, strictly the words, is a pattern of repeated or unwanted attention, harassment, contact, or any other course of conduct directed at a specific person that would cause a reasonable person to feel, and we see that reasonable person standard a lot in the law. A lot of times people don't act reasonably, but are not going to have a lot of leeway when it comes to these stalking issues. And
EEOC doesn't have a lot of patience for it either. So, if you've got someone who, you've got an employee and someone is stalking them and it's related to your work, you could have a real problem.
Exactly.
It's kind of like with the son situation where the son was doing the sexual harassment.
Yep. It is kind of like that, and it can be a very wide range of, employment-related areas too. Harassing the victim via the internet, that could be done through work means, that could be done through out-of-work means. So that's broad there, stalking as well.
All right. Domestic violence. Domestic violence and workplace violence also we're going to be talking about. We see these problems a lot. And the problem, of course, is that with domestic violence especially, we haven't had a lot of instances of it happening with home health or hospice situations, but we have seen a number of cases in recent years where an aggrieved husband went into a dentist's office, and shot up the place, including his wife or ex-wife or soon-to-be ex-wife. Same thing in doctor's offices. So, I mean, you have to watch out for these potential issues. And if you find out one of your employees is a subject of domestic violence, you can't take adverse action against them. I mean, that's basically blaming the victim.
Yeah, exactly. These things all need to be taken seriously. We just have a couple of listed actions here by management that are examples of what not to do. So, here, the first one, employer terminates an employee. That's an adverse action right off the bat, termination. After learning that she has been subject to domestic violence, saying, fear of the potential of a drama-battered woman bringing the drama that she would bring into the workplace. Clearly something that is not going to be acceptable in any workplace.
And then I think the second one's interesting because it also brings the gay question into it.
Yes, so believing that only women can be true victims of domestic violence as well. That one, so it could be a woman or a man. And then the third one here.
Yeah, but in the second one, they didn't select the applicant because the hiring manager found that the applicant obtained a restraining order against his male domestic partner.
Yeah.
And he's thinking, that's just too much drama for us. We don't want that here.
You're right, and that could bring in sexual discrimination under Title VII as well. So that shows how these issues intertwine, domestic violence and discrimination.
Yeah. Okay. So what do you do with reasonable accommodations?
Yeah, so how do you deal with it with reasonable accommodations? Again, we've got some examples of what not to do, and sometimes that's the best way to figure out what to do. We talk about bad faith a lot of times.
That's a good point.
You don't know what good faith is in the law generally. You know what's bad. So we had a couple examples here. An employee with no accrued sick leave was trying to get out after they wanted treatment for depression and anxiety following a sexual assault by an intruder in her home, and the employer denied the request because it applied leave and attendance policies the same way to all employees. So what to do in that situation? Take it with context. This is a employee that has been through a lot.
And they're not asking for, they're saying, I want to, it would be covered by the Family Medical Leave Act.
Exactly.
I mean, work with me,
Yeah. So there's some flexibility that needs to be had in these situations. Don't just deny someone that's gone through this traumatic experience because they don't have sick leave. That's something that's an approach that should be taken. Flexibility. And then the aftermath of an ex-boyfriend who was stalking in the same building. Employees get major depression. That's a common thing with these stalking situations. And her doctor stated it was exasperated by continuing work in the same location as an ex-boyfriend. So, as a reasonable accommodation of this disability, the employee requested reassignment, but there was a no transfer policy. That's another one where flexibility could say, we've got this open location. You really have a problem, an obvious problem with this ex-boyfriend working there. Let's be flexible, understand, be human, and just allow for some flexibility, a change.
For instance,
location.
If you're talking about it's difficult possibly with someone who has to go from home to home, but if you are talking about like your scheduler, these days with modern technology, let them work at home for a while.
That's true as well, and that just adds more flexibility, more options, and less problematic ways to deal with these things.
Yeah, I mean the whole purpose here, guys, is we don't want you to have to deal with these EEOC complaints. They get very expensive, both in terms of lawyers and in terms of potential liability. Last, we've got workplace violence. Now this is really interesting to me. 2 million people each year victims of workplace violence, and violence against healthcare workers is 5 times higher than the average U.S. worker.
Yeah, exactly. And so, that highlights, and we'll see on the next slide, the top 4. One of those is healthcare and social service workers. That highlights that in this healthcare industry that we work in, this is something to be very concerned about, workplace violence, something to be aware of, something to learn about, and that's what we'll share some tips on today for the event of workplace violence.
Yeah. Okay, so if somebody does come into your office, these are very basic tips that we pulled from the government, essentially. Try to remain calm, try to be respectful, listen to what their concerns are, try to get help, and get out of there if you can.
Don't try to be a hero. There is on there. Don't risk harm to yourself or others.
It really is tough. I mean, there are so many instances of workplace violence in healthcare environments that I just don't even know where to start. Now, from home health and hospice, I can tell you, once again, you're talking about the patients and their families are probably your largest potential exposure to workplace violence. You know, because these people, they may suffer from dementia, they may have organic brain syndrome, they may have other Alzheimer's, and they're confused, they don't know where they are, and they say things and do things that they would not normally do.
Exactly. Yes, and that just is probably one of the many reasons that healthcare is up here so high on the OSHA list for workplace.
I believe it is.
Yes.
Yeah. Next one. And I will say there is a really good course that is free, and it's offered by the National Institute of Occupational Safety and Health, and it's really intended for nurses, but for anyone in healthcare, it's a really good course to take. And that is our presentation for today. I know it's a lot of information. It's not information that we typically have been going over with folks, but we're happy to answer any questions. And if you do have questions in the future, you can give me a call or you can give Mike a call, and we'll be happy to address them. But the last thing I want to leave you with, though, is to go back to the very beginning. Healthcare is under the regulatory microscope, and yesterday I think is a perfect example of that. Hundreds of people arrested, billions of dollars in improper billings, and it really comes down to, especially in the area of home care and hospice. And in Texas, for instance, the big focus is home health. I mean, there's no question about it. In Louisiana, it's a little bit of both. But look at how you're getting your business. Look at where you're sending business, and that really is a good place to start to figure out your level of risk. Look at your medical director agreements. Do they send referrals to you? How are you paying them? Are you actually documenting what they're doing for the money that they're receiving? Because you can't pay for referrals. That would be a violation of the kickback statute. Yep. And if you're paying them fair market value, and is it documented what they're doing that actually supports the payments that are being made?
Exactly. Yep. So thank you, everyone, for listening to these important topics today, all of them. And also, as Robert said, take into account this DOJ takedown as well.
All right, so I'm going to close out the webinar. Thank you so much to our presenters, Michael and Robert, for that information, and thank you to our attendees for joining us today. I'll be sending a copy of the PowerPoint slides tomorrow via email, and if you have any further questions, like Robert said, please feel free to reach out to them. Have a good Tuesday. Thank you.